Hi, I'm Annie Fitzsimmons. I'm your Washington Realtors Legal Hotline Lawyer. This is another episode in our series entitled Buying Tenant-Occupied Property in a Just Cause State. And in another episode in this series, we discuss the steps required for a buyer broker to assist a buyer in ensuring that if a seller retains possession after closing, that landlord-tenant relationship after closing, where buyer is a landlord and seller is a tenant, steps necessary to ensure that that relationship is not subject to the Landlord-Tenant Act, at least under state law. And in that episode, we talk about the risks that some local laws might put the parties subject to the Landlord-Tenant Act, even if the state law does not reach that same conclusion. But what we never discussed in that video, in that episode, and what is so important for you to understand is, why is it important for the buyer as a landlord to not be subject to the Landlord-Tenant Act? Kaitlyn, any thoughts with respect to that?
Absolutely.
Oh, I'm sorry. Let me introduce who this is. This is Kaitlyn Jackson. She is an amazing landlord-tenant lawyer at Williams Kastner in Seattle, Washington. Kaitlyn, take it from here and tell us a little bit about yourself if you want to before we get started.
Yes, so my name's Kaitlyn Jackson. I've been practicing landlord-tenant law since about 2018, and I do a lot of transactional work of tenant-occupied property as well. And so these two pieces of the transaction and also just the practice of landlord-tenant law are my day-to-day.
All right, so why does a buyer as the landlord want to not be subject to the Landlord-Tenant Act?
The Landlord-Tenant Act, as it exists at the state level, has a lot of different duties and requirements and protections for both landlords and tenants. So an example would be, there's a whole subchapter about all the things that a landlord is required to do. For example, certain types of maintenance and repairs, or making sure that the property is habitable and making sure that they respond to tenant inquiries and requests in certain timelines. For example, if there's a water leak that is important and the tenant submits a notification to the landlord, they have 24 hours to respond and actually begin maintenance and repairs. Those lists of what a landlord is required to do and those duties is very extensive. So having a relationship where the landlord and the tenant are exempt from those requirements and the agreement that they have in place in writing governs that relationships is very beneficial in certain types of relationships, like a seller-buyer relationship.
And with respect to the repairs issue specifically, something that's important to add is that if buyer is purchasing property using Washington's statewide forms, the Form 21 has a provision that says the seller of the property is liable for the condition of the property, responsible to maintain the property in its condition, not through closing, but through possession. And so if you have a buyer who becomes a landlord but is subject to the Landlord-Tenant Act, you would now have a contract provision saying that the seller is responsible if something needs repair in the property, but you would have a state law, the Landlord-Tenant Act, saying, no, since buyer is a landlord under the Landlord-Tenant Act, buyer as the landlord is actually responsible for making any repairs necessary in the property. And state law would trump the contract every single time in that respect. And so by carving the relationship, you still have a landlord-tenant relationship after closing. Buyer is still the landlord, seller is still the tenant. But by carving that relationship out of the Washington Residential Landlord-Tenant Act, then buyer is able to take on the benefit, the contractual benefit bargained for when both parties signed Form 21, namely, seller remains responsible for the condition of the property until the end of seller's tenancy, or when seller no longer occupies the property. Anything else other than condition of the property that would be important?
Well, I think that if notice for termination, for example. So the Residential Landlord-Tenant Act has specific notice requirements if any tenancy is going to be terminated. Well, the great thing about the form, the 3-month form that we use with Washington Realtors or NWMLS, statewide form, is there's no more notice provided. So you don't have to provide additional notice to terminate, no additional information. It ends at the date and the time that form actually stipulates is the end. So long as the new owner does not accept $1 of rent past that deadline. So it speeds up the process quite a bit.
Let's put some facts around this to make it make sense. I'm the buyer, landlord. You're the seller, tenant. Okay.
Okay.
And we close on April 1st.
Okay.
April Fool's Day. We close on April 1st. So as of April 2nd, I'm the landlord and you're the tenant, but we have signed a post-closing rental agreement in advance that says that your tenancy, your right to occupy, will end on April 15th.
Okay.
So now, what am I as the buyer / landlord required to do to make sure that you are moving out on April 15th?
Nothing further, as long as you don't accept rent for April 16th. Once that deadline on that document expires, no more notice is required. Whereas under the Residential Landlord Tenant Act, there's different types of notice that still must be served in multiple circumstances. And so, for example, if it was a traditional landlord-tenant relationship and it is a single-family home, I, as the buyer or as the seller, could either give a 90-day notice of intent to sell. That's 90 days. I'd have to give additional notice, right?
Prior to closing. We just switched positions.
Yeah.
Okay.
Yeah. Prior to closing. Or if I'm the new buyer and I've stepped into those shoes, I am now the owner and I want to occupy that property, then it's a 90-day notice that would still be required. In this circumstance that you've just described, there's nothing else that needs to be done to ensure that my right to occupy the property expires on April 15th.
Let's take it one step further. And let's say that you just don't move out on April 15th. Now, what's the difference between, because if I, as the buyer in this scenario, even though we're not subject to the Landlord-Tenant Act, I still can't just come over and move you out of the property, right?
No.
So what's the difference in process that I would undertake to remove you when we are not subject to the Landlord-Tenant Act versus if we were? Is this something you can describe in, a couple minutes?
Yes. Well, that's because it's actually easy. It's the same. Whether you're the new purchaser and you've got an agreement like what we're talking about carved out of the RLTA, usually that process looks like an unlawful detainer, which is the fancy word for eviction. If it's a landlord-tenant relationship that is subject to the RLTA, so long as the new notices or whatever appropriate notices under the RLTA are served at some point and expire, it's still an unlawful detainer, generally speaking. There are other ways to do it. Ejectment actions are an example of that. But the general way forward is usually an eviction. And that looks like service of a lawsuit. Service of an unlawful detainer is summons and a complaint. And you move forward with what is considered an expedited process.
So once the deadline for a tenant to occupy passes, then if a landlord has to go to court to get them out, the procedure looks the same if you're subject to the Landlord-Tenant Act and if you're not subject to the Landlord-Tenant Act. Is that right?
Yep.
The difference is in the amount of notice that has to be given to the tenant before we get to that place where the tenant's rights have been terminated, and then you can, or should have been terminated, and you move forward with the action. Is that right?
That is correct. However,
Okay.
I'll make one distinction. One of the most important distinctions is the fact that in Washington law, under the RLTA, just by nature of the fact that the property is being sold does not necessarily mean that the tenancy can be terminated for that reason. So in a seller-occupied property that is a single-family home, that is a good place where the state will say, okay, you can do this notice, this carve-out. Whereas if this is a multifamily property and it's a rental property.
And multifamily, you mean 2 units?
Literally
or more.
duplex. It could
Yeah.
be a duplex, yeah. a landlord or a previous owner cannot necessarily terminate either of those tenancies just because they intend to sell the property. So those just one more reason why this carve out can be so valuable.
So to summarize how you accomplish the carve out, the opportunity for this carve out was created by state law in 2023. And the carve out requirements are that the property cannot have been a distressed property. The seller must have been represented by either a real estate broker or a lawyer during the negotiations or the closing process. And the third criteria is that the post-closing seller leaseback agreement can be for no more than 3 months of seller's post-closing occupancy, and buyer is prohibited from accepting rent for more than those 3 months. What happens if buyer accepts 3 months and 1 day of rent, Kaitlyn?
You are now a landlord under the Washington RLTA and likely any other local ordinances that apply to that property as well.
So even if you thought that you were ready to start the eviction action because seller's 3 months were up, if you accept 1 day of rent after those 3 days, then all of a sudden you're delivering 90 days notice or more in order to even begin the eviction action, right?
Right.
If you have questions on anything we've talked about in this episode or anything else, please ask me a question by visiting warealtor.org. Thank you for being a Washington Realtors member.